Today we have a guest speaker, Linda Crebbin. She's the General President of the ACT Civil and Administrative Appeals Tribunal. She's the General President there. Her former roles have included things like being the Commissioner for Children and Young People and also the Disability and Community Services Commissioner. She's also been the former Deputy CEO of the Legal Aid. Thank you, Linda. But I think, to my mind, Linda has always struck me as someone that is she's always wanting to make a difference, and she's always wanting to find a solution to things, whether it's in the law or whether it's just in relation to the administration of things. And so I've known Linda for probably 15 years now, and I think that she is really quite an inspiration in relation to just always wanting to find a solution to things. And that's why I think she's very well placed today to actually talk to you about tribunals and dispute resolution within that framework. Okay, thank you very much.
Thanks, Doris. Thank you. I get freaked out. I talk to people all the time. In fact, I talk constantly. It's one of the reasons why I became a lawyer in the first instance, because it's a career that people would pay me to talk. Wonderful career choice for me. But I get freaked out by cameras. So if I get to the point where I go like that, just give me a bit of a nudge and take my eye off the camera so I can get started again. Before I start to talk with you about alternative dispute resolution in tribunals, and particularly in our tribunal in the ACT, I think it's useful to think a little about, more broadly, about the concept of alternative dispute resolution generally. And this is something that you all have been doing for several weeks now, I know. So please excuse any boring stuff I talk about now and stuff that is very familiar to you. We know that dispute resolution processes that look fairly familiar to modern ADR practitioners have been around for centuries. Some commentators push the timeline as far back as 1800 BC. In an area that we now know of as part of Syria, there are descriptions of dispute resolution processes that look a bit like mediation coming from that time. Processes are considerably more benign than the dispute resolution processes that the citizenry of Syria are being subjected to now, unfortunately. And your readings probably, for this course, probably include some literature that tell you about that history, but I'm specifically referring in my comments to a publication called A History of ADR by Barrett and Boss, a US publication. And in that publication we learn about the Bushmen of the Kalahari Desert and Phoenicians and ancient Greeks and things that they've done to resolve disputes in a range of ways that still look familiar to us today. One of the things that strikes me when I think about that history is, if we're talking about this as alternative dispute resolution, what is this as an alternative to? And when we use that term, when I use that term in any event, I assume that most people are thinking of what we now describe as ADR processes as being an alternative to a court-based dispute resolution process. So I find it also useful then to reflect on what the court system involves as far as a dispute resolution process goes, so that I can put that concept of alternative dispute resolution into a context. If I think about the court system, the history of the court system that we know is nowhere near as long as what I've just described to you. It doesn't go anywhere near 1800 BC. Our court system really has only evolved for the last 1,000 years, or slightly more than 1,000 years. It's a court system, a common law court system, that we share with more than 1/3 of the world. Mostly they are the countries that have been connected to the British Empire, the British Commonwealth. You've only got to remember that includes India to recognise that, in fact, in terms of the proportion of the world's population, it's a very large group of people that we're talking about that have a court system that is part of our own heritage. Its origins, you can trace back to dispute resolution processes involving trial by ordeal, which was banned by William II in the last years of the 1000s. So after 1066, when we tend to think of the time as the development of our modern concepts of parliamentary democracy, we still had trial by ordeal. Trial by combat was what came next. Trial by combat actually involves a concept which is very relevant in modern day discussions about alternative dispute resolution. Trial by combat over a period of time was regarded or recognised as being unfair because it often involved an inequality of arms. So that concept of equality of arms, which is often talked about as a concern for people in alternative dispute resolution processes, actually dates back to trial by combat. And it's still a term, equality of arms is still a term that is often used in modern discourse about our legal systems and our court systems. In fact, I was having a discussion with a fellow who's recently been appointed as the CEO of our Legal Aid Commission here last week, and we both talked about the importance of equality of arms and the importance of the legal aid system in that context. So we still use that concept from all of that time ago. Henry II, whose reign was between 1154 and 1189, was the first to establish a jury, 12 knights, to settle disputes over the ownership of land. So here's a bit of a new development. We've got a broader panel of people resolving disputes between citizens about land things. Am I creeping too far forward? Am I? I'm sorry. I realise now that you looked a bit panicked, as though I might end up in your lap if you're not careful. I understand that. So really it's from those times that we've evolved a court system, a legal system that is familiar with what we have today. And there are some essential features of that court system, of that legal system, that are significant to keep in mind in any modern analysis of the role of ADR. They are these: open justice, openness of justice, fundamental to the legal system and the court system that we have. The concept that law should be seen to be done, that justice should be able to be seen to be done, involves a concept that hearings, dispute resolution processes take place in public, that what happens in those processes are transparent and available for other citizens to see and to develop a confidence in those processes in. That the outcomes of those processes are public and are published. And we see that today spelt out very clearly in Section 21 of the ACT Human Rights Act. That's the section that sets out in legislation the fair trial process. But if you read Section 21, you'll see that it goes beyond a fair trial process and incorporates publication, the idea of public hearings and the publication of the outcomes of those hearings, fundamental to our legal system, that open, transparent process. Also key features that decisions are made according to law, following a fair process, with an authoritative decision made by a fair and unbiased adjudicator. A system in which members of the public could be confident that if this gentleman and I had you wish you hadn't sat at the front now, I know. This gentleman and I had a dispute and we went to a court, we had that dispute resolved, and then the following week, in a particular way, and the following week he had a dispute that was essentially similar with the young person next to him. They could go to the same court, maybe have a different magistrate, a different judge, get the same outcome, confident in the consistency and quality of authoritative decisions. That type of system we've had in place now for many years, and that's regarded as a fundamental part of a stable, peaceful community. When we talk about parliamentary democracy and our democratic systems, that type of court system is a fundamental part of such a society. So when you think about those concepts, open justice, consistent outcomes, things that are transparent, where decisions are clearly made according to law, and then put those up against what we usually understand occurs in an ADR process, you can see that there's potential for considerable dissonance. And I think that this is an important part, that fact is an important part of any dialogue about the role of ADR systems in court systems. A few years ago, Athol Morris and I sat side by side at a cringing, actually. At least I was. Were you cringing? Yes. At a conference where the Chief Justice of the High Court was speaking, His Honour Justice Robert French. Wonderful speaker, wonderful judge, wonderful jurist. But what he spoke about was his concern that there was a risk that tribunals and all of the dispute resolution processes that they used could undermine that important part of a good, stable democratic system if the predominant paradigm in a tribunal became mediation, negotiation to resolve disputes. And he urged the group he was speaking to be cautious about the idea of mediation, conferencing, as being the main way that we were going to do our business. It was a conference that involved tribunal members and tribunal registrars. And his analysis of this struck me as being very, very conservative. But when you think about why we have the court system that we do, it makes sense that there would be a concern about the risk that systems that insist that everybody go through an ADR process and put hurdles in the place of people having their disputes determined in public open hearings in court. You could understand why there would be some concern, particularly from members of the judiciary, about that and what that might ultimately lead us to if we went down that path too far. So those things are the things that I often think about when I am looking at what use we should make of alternative dispute resolution processes in the ACT Civil and Administrative Tribunal. And I think if any of you who become ADR practitioners and who work either in or in conjunction with court systems or with lawyers who may not have fully embraced the concept of ADR, they're concepts for you to think of as well and to bear in mind, because it will often explain what that reluctance is of certain people to be involved in ADR processes, or why courts sometimes don't seem to embrace the concept of the use of mediation and conferencing as strongly and enthusiastically as you might. So, ADR in tribunals. Tribunals also have a very ancient heritage in the legal system generally, but what we have now as tribunals doesn't necessarily bear much resemblance to tribunals of many years ago. The history of the modern tribunal in Australia and internationally is very recent. It really commences in late 1979, late 1970s, and in 1980 with the release of a very significant report about tribunals in Australia. It was that report that influenced the development of the modern day tribunal in a range of other countries, not just in Australia. As a result of that report, the Commonwealth Administrative Appeals Tribunal was established, first in late 1980, I think it commenced. And in the law that establishes that tribunal, there was reference to the use of conferencing and alternate dispute resolution processes to resolve disputes. I'll just tell you a little bit more about tribunals for a moment and what's happened since the establishment of the Commonwealth AAT back in 1980. For many years there was a proliferation then. Everybody thought this tribunal stuff was a really good idea. So a proliferation of tribunals and other bodies that are essentially dispute resolution bodies with different names, some of them called boards, some of them called commissions or commissioners, all established for the purpose of resolving disputes in a less formal way than disputes traditionally resolved within court systems. Usually subject specific, so you would have a tribunal set up for the purpose of dealing with disputes or investigating complaints for a particular subject area. So after 20 years or so, we had this enormous proliferation of these types of bodies in states and territories all around Australia and at the Commonwealth level. There was then a bit of a movement towards identifying that there was a lot of commonality in the theory, the jurisprudence relating to tribunals, and that perhaps we didn't need to have subject-specific tribunals, but that we could bring these bodies together in some way. So this led to the development or the establishment of the first, what we sometimes call super tribunal. I call a multi-jurisdictional tribunal. This is sort of a super tribunal has, I always somehow connect it to, you know, a supersize me McDonald's type thing that makes me feel a bit nervous. So multi-jurisdictional tribunals, the first of those being the Victorian Civil and Administrative Tribunal, VCAT. What was unusual about VCAT, not so much that it brought together a large number of these tribunals, boards, commissions that had been established in that period of time, but also that it included work that was outside the traditional framework of tribunals. Tribunals had been mostly concerned with what we call administrative law, government law. So the Victorian Tribunal, when it was established, brought into it disputes that were not about administrative matters, disputes between a citizen and a government entity or an administrative entity or a regulator, but also disputes between citizens themselves, inter partes disputes. I should just check, are most of you doing a law degree or have an existing law degree? Okay, so inter partes disputes. So the civil part of it was something that was a bit novel. So VCAT is the first CAT, and that as a CAT was around quite a long time before the next one came along. Western Australia followed. They haven't quite gone down the path of a CAT, they just have a SAT. That's the State Administrative Tribunal, or WASAT, if you like. And WASAT brings together guardianship and a number of administrative areas of bodies in Western Australia. 60% of the work of WASAT is in fact guardianship law, which is quite a different profile from the other multi-jurisdiction tribunals. WASAT was followed by our tribunal, ACAT, which led to all sorts of great fun when we were looking at logos for the tribunal with unfortunate pictures of cats in unfortunate positions, none of which, of course, we considered seriously for a moment. So ACAT, February 2009, bringing together about 23 different dispute resolution bodies. Some tribunals, boards like the Liquor Licensing Board, commissions, some of the roles of the Fair Trading Commissioner were brought into the tribunal to form what we've got today. QCAT, Queensland Civil and Administrative Tribunal, 12 months later in January 2010. January 2014, we will have NCAT, the New South Wales Civil and Administrative Tribunal. That'll be an enormous body. The South Australians have a bill before their Parliament, it just had its second reading speech last week, I think it was. That will be SACAT. Any of you who are involved in any criminal type activities or law may know SACAT as being the acronym for the Sexual Assault and Child Abuse Team, which is an acronym used throughout policing in Australia. So I don't quite know what the South Australians are going to do about that. ACAT, of course, is also the acronym for the Commonwealth Aged Care Assessment Team. And that causes enormous confusion for us, particularly because that body's located on the second floor in the same building that we're in. But, you know, I sort of feel a bit happier about being associated with the Aged Care Assessment Team than I would about being associated with sexual abuse or child abuse. Anyway, that's the South Australians' problem. And the Northern Territorians have announced an intention to probably establish an administrative appeals tribunal. The law about tribunals in the Northern Territory has really never developed, and so they're looking at just bringing together some of their administrative decision-making roles into an administrative appeals tribunal. So the time of the CATs, the super tribunals, has really arrived. And one of the things about tribunals that is important to know, it's a saying, a trite saying that applies to them. They are creatures of statute, so they're established by a piece of legislation, and they have the powers that are given to them by statute, and only those powers. So everything that we do as a tribunal is determined by a legislative power that we have. And in all of the legislation that establishes these multi-jurisdictional tribunals in Australia, you will find provisions that give power to the tribunals to use dispute resolution or alternative dispute resolution processes in some way in their operation. So VCAT has quite a lot of provisions. While there are a lot of differences, there are actually some similarities. So in VCAT, they have a thing that they call a compulsory conference. A compulsory conference. That's an interesting thing to think of in terms of what you know about the principles of alternative dispute resolution and all that voluntary stuff. So Section 83 of the VCAT Act, parties can be required to attend one or more compulsory conferences before a member of the tribunal or before a principal registrar before the proceeding is heard by the tribunal. And then they set out a list of what those functions are: to identify and clarify the nature of the issues in dispute, to promote a settlement, and if no settlement, then to identify the questions of fact and law that need to be determined in an adjudication. So compulsory conferences, they're given statutory confidentiality, evidence of things that are said during the course of conferences inadmissible in any later proceedings. Party to a matter can object to the person who has dealt with the conference, who's convened the compulsory conference, going on to have anything further to do in the matter, so to preserve the concept of the confidentiality of the process. If you fail to attend a compulsory conference in VCAT, it can go ahead without you. That's a bit of an interesting process. And in fact, orders can be made against you. If you're the applicant, the matter, your application could be struck out. If you're the respondent to the proceedings, then the orders that the applicant seeks can be made against you in your absence. So it can sort of convert from this ADR process into what's a sort of ex parte or default determinative process at that point, if you're not there. That feature is common to all of the tribunals, that type of statutory power. VCAT also has provisions that allow matters to be referred to mediation. So they draw the distinction between those two things, a compulsory conference and mediation. Mediation for VCAT carries with it a fee. There aren't any other real requirements for mediation, as to nothing else in the law in Victoria about when they can occur, but again, the parties can be required, ordered to attend the mediation. Our tribunal's provisions, in a way that I find is very interesting, are actually placed in a part of the ACAT Act that is headed case management. So in the section of our Act that deals with case management, we're told that the tribunal can take steps to resolve matters before a hearing. Then we're told that we can require people to attend a conference. So it's not called a compulsory conference, we actually call it a preliminary conference, but it really is a compulsory conference because we can require people to attend. And we do. Our Act doesn't actually say what the purpose of the conference is, but during the course of a conference, the person conducting the conference can ask questions, obtain information, require that information be provided to them. So the idea is that it's some form of inquisitorial process, and what we do with it in practice is to treat it in much the same way as the description of the compulsory conference in VCAT. And Athol will work with you later on, I think today, to give you an example of how that works in practice. So I won't tell you too much more about that, other than to say we focus on trying to identify, ensuring there's a common understanding of what the dispute is about. Is there any prospect of settlement? And if not, then using it as an opportunity to educate the participants about what needs to be done and to give them directions about what needs to be done to get the matter to hearing. And the purpose of that latter part is to ensure that when the hearing comes around, as much as we can ensure, when the hearing comes around, those participants are fully prepared to participate in the hearing on that day, that they've got the evidence they need. They understand that they've seen the other side's evidence and the matter is ready to go smoothly. So it has a bit of an educative process as well. In addition, Section 35 of the ACAT Act says that we can conduct mediations. We may refer people to mediation if we are satisfied that the matter is reasonably likely to be resolved in mediation and that it is appropriate matter for mediation. And if we're satisfied of those things, we can require the parties to attend. So again, there's this compulsive component of it, of that mediation process. And because we're in the ACT, where there is a Mediation Act, and there's a requirement that all mediations be undertaken by registered mediators, our Act says our mediations can only be conducted by a registered mediator. Then again, there's a provision that's about evidence not being admissible, etc., and confidentiality. So all of these super tribunals and all of the other tribunals that aren't super have some sort of similar process in their legislation, save perhaps for guardianship and mental health tribunals. But I'll come to that in a moment. I've no idea what the time is, and I can talk forever without stopping or looking at notes. 2:05. Thank you. All right. So now I'll come to talking about what we actually do with conferencing in the tribunal. So we use ADR a lot, and I personally don't believe that we will ever see a time in which it will become the predominant paradigm and will overtake the court system. There will always be a need for a court system, and so I'm not as concerned about the sky falling in if we do too much of it and we start to get pushy about whether people should look at these processes before an adjudication. And there are a range of reasons for that. It's because there are people who simply want somebody else to make an authoritative determination, but also because there are other types of cases which aren't really appropriate or amenable to ADR processes. I don't think that is a lot of cases. I think there's a lot of criminal matters that are very amenable to ADR processes, and that's probably not a normal view, but certainly there are some that in which it's got to be used in a particular way or not at all. So in our civil dispute area, where an application is filed, a respondent puts in a response, the parties are required to attend a preliminary conference. We don't use mediation at that stage, and Athol will tell you more about those. In a residential tenancy matter, if your application is for the termination and possession of an order, that needs an authoritative decision. There's no point pushing that into a dispute resolution. We've got a lessor who, for whatever reason, wants the tenant out of their premises. So those matters go straight to hearing. If we have a residential tenancies dispute that is about a tenant seeking compensation for breach of a term of their residential tenancies agreement, it may be that things haven't been repaired or the landlord's been a bit of a nuisance and breached the right of quiet enjoyment, then that goes to a conference. Or if you have a landlord seeking compensation when a tenancy agreement has come to an end for damage done to the property, that goes to a conference. Any dispute about a rental bond comes to the tribunal, goes to a conference. So there's an enormous use of ADR in that process, and the way in which we incorporate that as part of the process ensures that we use ADR, both, as I said, for that dispute resolution process, but an educative process as a step before the hearing. So very much as a case management tool, and it assists rather than hinders the workflow through the tribunal as a result of that. So if you lodge an application for a dispute about a car accident, say, the other side puts in their response, you could expect at the moment 3 to 4 weeks before you go to your conference. And that's actually a useful time. People have to have some time to prepare themselves and get all of their receipts and other bits and pieces together for that. If the matter's not resolved at the conference, you will have a hearing date set that is 4 to 6 weeks and sometimes 3 weeks away. So from the start to the finish of the process in the hearing is actually, in the scheme of things, quite a small period of time. In our mental health areas, we don't really use dispute resolution processes at all, and it's hard to see where you might call on such processes. I sit on those cases. They need to have a presidential member on them, and I draw on the skills that I learnt when I did a mediation and arbitration course a number of years ago in the running of those hearings. They're not adversarial hearings, and the skills that you have as a negotiator can be very, very useful when you're actually running a hearing, particularly in the mental health framework, where I try very much to see whether I can, through the course of that hearing, create a situation in which the person who the application is about is almost persuaded to agree to the order that's being made. That can be a bit tricky, but that's an approach which I think is a useful therapeutic approach to that hearing process. In our guardianship areas, there is some scope to use ADR processes, but we don't. And I'll tell you a little bit about that. In our guardianship area, we have the power to appoint a guardian, a substitute decision maker, for an adult who is, for some reason, unable to make their own decisions about health or welfare matters, or we can appoint a financial manager for that person. Now, there's not a lot of scope for ADR processes in that part of our work, but we also have powers to revoke enduring powers of attorney that people have made before they've had a decision-making incapacity. We can give direction to guardians or managers about decisions that they should make. We can review our appointments. And there are quite a lot, I'm sad to say, quite a lot of these cases in which we have disputes, usually amongst family members, about decisions that have been made. For poor old mum Linda, who's completely lost her marbles, or a decision that hasn't been made. Very often the dispute can be traced back to a concern about money. Not always, but very often it is. And what we're doing in those matters, in our hearings, are actually stepping in to resolve this dispute. Those cases, if you're a family law practitioner, those cases look a lot like family law disputes, with usually more parties involved. Now, there's a move, particularly driven out of Canada, to use mediation in those types of cases, and the Canadians have published a lot about how they've undertaken mediation in guardianship matters and in what they call elder abuse cases very successfully. The fellow who runs the South Australian Guardianship Board used to be a family law practitioner. He uses mediation, his version of mediation, which is really more directive than real mediation. He uses that regularly and says he has fantastic success in doing that. He has a member who he's trained up to do intake and assessment, to assess which of those cases are going to be useful for that process, and he's worked up a process for how he and a couple of other members can run a conciliation process, and he says very successful. I was inspired by that because I've been a family law practitioner in the past, and family law practitioners are very heavily into ADR. So I've tried it a few times at ACAT, and it's been a complete disaster. And the worst case was I was hosting a meeting of the heads of guardianship tribunals at our tribunal one day. It was on a Tuesday, and I very foolishly, but as a result of a bit of pride, and I'll never do that again, listed a conciliation type conference for one of our members that afternoon while the heads of tribunals were meeting in a nearby room. During the course of the afternoon, there was this awful screaming and screeching and wailing that occurred. It really sounded as though somebody was having their throat cut. And I tore out of the room I was in, and there in the foyer of the tribunal was this very elderly lady who was wailing and screeching that we were trying to lock her up and put her away in a home. And from the room next door out came one of our members who's done a lot of conferencing work, looking horrified. The conciliation had gone appallingly wrong, and elderly mum with advanced dementia had heard everything as being about her being locked up. And the whole thing was, it took hours to calm her down. It was just, so I then was taken aside in a huddle by the head of the South Australian Guardianship Tribunal and given a lesson on how to do it properly. I have tried it a few times since, but it hasn't been quite as disastrous as that. But what has gone wrong? I've tried doing it ourselves, and I've tried referring matters out to the Conflict Resolution Service to bring back in, and it's not worked. And one of the reasons why it hasn't worked is that the outcomes that have been agreed in all of those cases have been outcomes which cannot be endorsed by law. So, you know, the 6 brothers who were fighting about their mum and her property came back to the tribunal from the Conflict Resolution Service, having brokered an agreement which would see them all sharing the role of attorney under the enduring power of attorney mum had made some years before, appointing one of them as an attorney. That outcome is completely unlawful. You know, and I had to say to them, oh, I'm really sorry. I mean, I know you think this is a great idea, but I actually can't make orders in these terms. We can't do that. The law won't allow me. The tribunal can't make an order that is not lawful. And that resulted in one of the brothers getting very angry, standing up, coming up very close to me and saying, well, why the fuck did you make me go into that room with these people that I hate and sit there for 3 hours thinking I was going to come to some agreement? Why did you do that? So I haven't tried that since. So if any of you like to take that on as a bit of a project, looking at the use of mediation in guardianship matters, going to be it's an increasingly important area of law, particularly with the UN Convention on the Rights of People with Disabilities. Please have a look at it. If you've got any bright ideas, come and let me know. Come and talk to me about it. We might run some trials. We use a lot of mediation because we have registered mediators as members in our administrative law work. And in fact, pretty much in every administrative review case, the standard directions that are made that the parties are to be referred to mediation, the application is referred to mediation, parties must attend the mediation. Some cases, the mediation outcome rates for me as a manager are not as good as they should be, as I would like them to be, I have to say. Our settlement rate is somewhere around at or slightly after mediation, sitting around 28%. It should be more than that. There are a range of reasons why this isn't more successful than it should be at that point. One of them is that a lot of the work we do in that area is revenue work, and here's a bit of a conundrum for you. Many government agencies involved with finance, with revenue. The tax office, for some reason, is a bit of an exception to this, funnily enough. They very much cling on to the idea that they're responsible for taxpayers' money, for the public purse. And their capacity to negotiate around that, to make decisions that might lead to the waiving of some or all of a debt, or to compromise on a debt, they will see as being very limited. And indeed there are limits placed on them. There is a limit to the discretionary decision-making scope in those matters. Having said that, the tax office runs a very successful, and has for some years run a very successful alternative dispute resolution process. So I presume they must have done something that gives authority to their staff who go along to those processes to waive tax debts or some part of them, or come to arrangements about payment by instalments over a lengthy period of time that actually allows there to be a meaningful outcome to revenue matters. But we do a lot of payroll tax, land tax. This is where lessors have failed to declare the income from properties they're leasing and they get slugged for. Tax they haven't paid, plus penalty, plus interest. We're doing a lot of that this year. There are a range of revenue matters that the Tribunal does, and I can only think of one of those cases that have ever ended up in a resolution. We push them into mediation because sometimes we think that the parties having an opportunity to hear and talk to one another, maybe there'll be something new come out of it, or maybe the applicant will realise now that the decision that has been made is correct and can't be changed, so they'll go away. But that doesn't happen either. So not much use in those matters from my perspective at the moment. Also in our planning and development areas, there's a lot of mediation in those areas. Those matters that involve neighbourhood groups, residents' associations who are objecting to development proposals, they don't usually settle either. They'll go some way down the path of agreement, but you know, some cynics will say that's because the residents' association haven't got anything to lose, and so ultimately they'll back away from agreement. I don't know if that's what happens, I don't know, but you know, the settlement rate isn't as good as what it should be. Maybe that says something about our process, but I think that it's more about the nature of the case. Is that that's telling me that time is coming, Athol? The other area in which we're using conferencing and mediation is very controversial, and it's something that I want to leave you with to think about a little. One of the major areas of work that we do, and all other multi-jurisdiction tribunals do, is disciplinary or regulatory work. So tribunals typically are the place that disciplinary action is taken in respect of someone who is licensed or registered to undertake some sort of occupation or profession. So lawyers, in future when mediators are all licensed or registered, you'll come to us if you're being naughty. Health practitioners, so doctors, psychiatrists, psychologists, nurses, etc. Security guards, liquor licence holders, architects, surveyors, teachers, the list goes on and on. If you have a licence or you're registered in order to conduct an occupation, all of the construction occupations, all of the builders, plumbers, surveyors, engineers, etc., they all come to us. Now, if you think about a regulatory process, what that is, this is where a regulator, a government authority, and in our case a tribunal, is making a finding that someone has done something that contravenes an act or has contravened a professional obligation, a conduct rule, for example, that is placed on them. They've acted in a way that involves professional misconduct or unsatisfactory professional conduct. Or they might lack competence. So in the health area, there's a concept of professional impairment that is added to that. Is there a role for negotiation and mediation in those matters? The regulatory authority is saying to the tribunal, we want you to make an order reprimanding that person or fining that person or suspending that person or cancelling that person's licence or recommending, if they're a lawyer, that they be removed from the role, that they be struck off the role of practitioners. Is there a role for mediation in those cases? When the Super Tribunal started, the answer to that would be absolutely not. That's a very important process to be undertaken in that public hearing context. No deals behind doors. Lawyers have been long criticised for this, and doctors, that they protect their own, and if there's a bad egg, they do deals behind closed doors and don't get punished for it. So the idea of some sort of mediation or conferencing process is really quite at odds with the idea of alternative dispute resolution. But the Victorians started trialling the use of a conferencing, compulsory conferences in their regulatory matters about 6 years ago. The Western Australians have been doing it since they've started, and I copied what it is they do. Most of my work is completely derivative. So what we do in those matters now is some matters are not appropriate to go to some sort of conferencing process, but actually most of them are. So I set them down for a preliminary conference with a member who's got some personal expertise in that relevant area of profession. I don't have any security guards on the tribunal, but have some knowledge about that profession. And we try to get the parties to a point where they feel that they can make a joint proposal. And so it might look like this. Here is an agreed statement of facts. We have reached an agreement. So if we get to that point, we've done well. We've saved several days of a hearing. Here is an agreement about how we say the conduct that is established by those facts should be characterised. That this conduct should be characterised as unsatisfactory professional conduct or professional misconduct. So we agree on that. Here are an agreed set of mitigatory factors, things that we think the tribunal should take into account in looking at a penalty. And this is what we think would be a reasonable penalty. So we may get some way down to any of those stages. The matter then goes into an open public hearing from the conference, and sometimes often by the person who has convened the conference, because the parties are comfortable with that. And in that open public hearing, the tribunal considers that joint submission or joint proposal. If they've only got so far as an agreed statement of facts, we'll run a hearing on the rest. If they've got, and this is more common, they've got an agreed statement of facts, they've got an agreement about how you characterise the conduct. What they've not agreed on is penalty. The tribunal will go through that agreed statement of facts. The tribunal member will say, actually, we think there's a relevant thing here you've missed out. We're going to add that in. This is your characterisation. Yes, looking at that agreed fact, those agreed facts and the law, the tribunal is happy to find, so the tribunal makes a finding, doesn't make an order by consent, but a finding that that's how the conduct should be characterised, and the tribunal will then make go through an independent hearing process to make a finding about penalty. Very often, even if an agreed penalty is put up to you, then what the tribunal member will do will be test that penalty. Well, why should I only, and in fact we've got one of these matters next week, a liquor licensing matter. Why should, and I can say it because it's all a matter of public record, because it's public, why should Siren Bar in Gungahlin be fined $500 for serving alcohol after midnight when their licence says they have to stop at midnight? Why should they be fined $500 and be asked to enter into an undertaking for apparently destroying the CCTV footage that establishes that they were serving alcohol after 12 o'clock when they knew that the police had already asked them to preserve it and make available, and oops, 7 days later, accidentally destroyed? Why should that only be $500? Well, there may be very good reasons why that's what's proposed. There may be very good reasons for that. But the tribunal member will get the parties to explain what that process is. We'll test that. We'll put propositions to them about, well, I think, something else should happen. A few months ago in another liquor licensing matter involving the Hippo Bar, and the Hippo Bar twice having a bucket and a mop or boxes blocking the back entrance, the fire exit at the back of the building. I don't know if any of you hang out at the Hippo Bar. It's been reopened recently, I understand. I don't hang out at the Hippo Bar, but I have been there once. And you'll know that it's upstairs and it's up very, very steep stairs, and the fire exit is down back very, very steep stairs. So at the bottom of that very steep stairwell, there are boxes and buckets and mops and crap between you and the fire exit. So it was proposed, a particular penalty was proposed of a reprimand and an undertaking and a fine of $1,000. I didn't think that was sufficient. I heard why the Commissioner thought that was appropriate. I heard why the Hippo Bar fellow thought that was appropriate. And I said, well, I hear all of that, but actually I think this is a really serious thing. To do it once is serious enough, but to do it again 4 weeks later is appalling. The risk that you're taking is enormous, and so this is the penalty that I think is appropriate in all of those circumstances. And what ended up was a reprimand, an undertaking, a requirement that a safety policy manual be amended, that every staff member undertake training and sign a document indicating that they have been advised about the fire evacuation and safety standards, and a penalty of $3,000 to be paid over a period of 3 months in 3 instalments. Now, that hearing process took me an hour, and the mediation, that conferencing process beforehand, had taken an hour. If we had held a full hearing on that, we would have taken probably not much more than a day, but the costs would have been much greater. The end result, I thought it was satisfying, because it's always, it's also, we've all got a little bit of us that likes to, give somebody a slap over the wrist sometimes, but putting that sort of sadist part of me aside, to get to that point actually required the licensee and the regulator to work together and to come up with an agreed new safety procedure, new process for ensuring that staff were trained. That educative process, that's an educative process again that we have managed to put in place through the dispute resolution process, much more satisfactory in terms of the long-term outcomes than an adversarial hearing, where that relationship between the regulator and the licensee would not have been developed. And by the end of it, of course, the two of them were finding that the tribunal was the bad guy in the room. So I suppose the message from that is then that that area, an area that on the face of it isn't suitable for alternative dispute resolution, tribunals across Australia now are using dispute resolution processes to get what I think of as therapeutic outcomes that are endorsed by the tribunal without impinging on those concepts of the importance of open justice, fair processes, authoritative decision-making, adjudication. I think that that's a wonderful thing. I'm really interested in that and how that progresses. I've talked for more than I should have, Doris. So I apologise for keeping you for longer. And there's no time for questions. No time for questions.
Thank you very much for that, Linda. It was very interesting and informative. And also I think just the fact that you were talking about how the tribunal here is looking at models in other jurisdictions as well, like Canada and Victoria and Western Australia. That was very interesting. And just the fact that you talked about real life examples, I think was useful. But so can we thank I understand, even though I gave you wrong directions as to how to get here.
Well, you know, yeah. Where's the South Gate? Where is the South Gate? It's not on Ginninderra Drive, is it?
No.
No, that's all right. I can't tell left and right, but I can tell north and south, so
yes,
that was okay.
Yes. Now, I did get you a bottle of white wine. Now,
yeah,
Athol
lovely.
said that that's your preference, so I was going to get red, but he said white, so you can blame him.
The reality is I drink
When I spoke to you the other night, you were drinking red wine, so I thought, oh, well, maybe I should have got you red wine. But
yeah, well, we don't need to share any more about what my personal habits are with the students.
Look, there is still a few minutes if anybody would like to ask questions, if you have still some time.
Yes, certainly, I have some time. And I'm happy if anyone wishes to send me an email with a question in it via the tribunal email inbox to answer questions later on. Yes.
I just have a question about the process of the disciplinary things. So once they've made their own sort of recommendations, like you said there with the $1,000 penalty, do they have to sign something or say something if they understand that the tribunal might come to a different decision?
No, they don't. They don't. But we hold a thing called a directions hearing first, and in the directions hearing, I hope that we make it clear that the tribunal doesn't necessarily have to agree with what it is they're putting forward as a proposal. So what you've said is a very important thing. We make it clear that the most that they're doing is putting together that joint submission. And I like the way you've described it as a recommendation, because that really is what it is. It's a joint recommendation coming from the regulator and the person being regulated to the tribunal.
So does that often happen, that you make a different decision, or is that
in the legal practitioner matters, we've got one member in particular, very, very experienced senior lawyer, very respected within the profession. He will regularly, what I think of as tweaking, will tweak the recommendations that the parties have put forward. So he will regularly say something like, well, actually, I think that you need to agree to have a senior lawyer mentor for the next 12 months, and that you need to agree to a meeting with that mentor or supervisor, or I want you to go after counselling, and so he regularly does that. Not necessarily, in the liquor licensing matters, we've done a few of these lately where we have departed from what the parties have agreed, and that we've got a review of the changes to the Liquor Act coming up. That's an ACT government review of the Liquor Act that the tribunal is a member of. And I suspect that there'll be a bit of a discussion about why it is the tribunal's imposing a higher penalty than the regulator thinks would be appropriate. But in the other areas, not so much, no. No, we tend more to endorse what's been agreed. Yeah. In the building area, I think it's the regulator understands that building area so well that there's not a lot of extra value that I can add to what comes forward from there, I found. Yeah. Any other questions? Yes, sir.
Just along the lines of the tribunal ordered mediation, so if you guys determine that it's appropriate for mediation, does that take away the scope from the practitioner to decide that it's not, but based on pre-mediation?
No. So I should have told you a little bit about that. So the registered mediators, we actually are actually members of the tribunal. These processes, in common with all of the other tribunals, remain in-house. We don't engage external. So that's part of the case management. It's that part of that case management. So the mediator knows. The mediator is still working on the basis of their what do they call them? You know, their requirements. And so they'll conduct pre-mediation meetings and assessments in the usual way. And I regularly have them ring up or come in and say, you know, this matter you've given me, this isn't going to resolve. Are we really going to go to mediation? In fact, that happened last week. I sent a dispute around a Heritage Council decision in Turner to a mediator. And the mediator said, you know, and in fact the parties had said, we aren't going to mediation because we're not going to agree with that person. And I had said, I mean, I don't think this is breaching anything, because it was also in the course of the directions hearing, the ACT government said the chair of the Heritage Council will come to the mediation and he is prepared to answer whatever questions you put to him about what they decided, why they decided it, what their process was, and you're not going to have that opportunity in any other process. And when they thought about that, they said, well, you know, we still think it's probably not going to resolve, but that's a fantastic opportunity and we want to take it up. It's another example of the use of mediation as a therapeutic process. For those of you who aren't familiar with the concept of therapeutic jurisprudence, and if you're interested in that sort of thing to inform your practice as a lawyer in the future, I encourage you to look at that and to think a little bit about how those therapeutic jurisprudence principles play out or can be made to play out in this alternative dispute resolution framework. I don't think there's any writing on any of that. Have you thought about the use of ADR as a therapeutic jurisprudence tool? It'd be interesting to see whether those ideas develop in time. Any other questions? Yes.
Just one even roll on from that one. I think you mentioned earlier that the tribunal generally doesn't get involved in mental health cases.
Oh, no, we do mental health cases, but we don't do any alternative dispute resolution processes in mental health cases. We are the only multi-jurisdiction tribunal that has an original mental health jurisdiction. Yeah, the others, they've maintained, they haven't brought their mental health boards or mental health tribunals into that super tribunal framework. Yeah. Yes, ma'am.
For the purpose of equality of arms, who will come to the table? And are there any possibilities that one party will discuss away from the table at some stage?
Who comes to the table is whoever the individual party wants to come and wants to bring along. And from my perspective, the question of whether or not there's an opportunity to take time out and go and ring a friend or go away and get some further advice is a matter entirely for the mediator conducting the mediation process. So we don't put any limits on that. It's something that needs to be sorted out in the mediation process.